and welcome to today's Ekatva webinar session. This is Ravi Mudaliar from Ekatva, and today's topic is Trademark, a Lawful Insights. It is my pleasure to introduce our speaker for today's session, CS Bhagirathi Mewada. Ms. Bhagirathi is a qualified company secretary and holds a bachelor's degree in accounting and finance. She has been associated with the Money Plus consultancy services for the past 4 years, during which she has gained extensive hands-on experience in corporate and legal compliances. Her core areas of expertise includes handling private company compliances, incorporations, strike-offs, private placements, right issues, secondary market transfers, and annual compliances. In addition to corporate law, she has significant experience in intellectual property matters, particularly trademarks. Her work includes trademark application, submissions, cease and desist notice, objection replies, and opposition proceedings. She also actively represents matters related to RERA litigation, handling submission before the authority, the adjudicating officer, and appellate tribunals. With a strong blend of practical experience and legal insight, she brings valuable real-world perspective to today's session. Please join me in welcoming CS Bhagirathi Mewada. Over to you, Bhagirathi.
Thank you so much, Ravi, for the wonderful introduction. I'll start with sharing my PowerPoint presentation. Just a second.
Yeah, it's up, Bhagirathi.
Okay. So, good evening, everybody. As you all know, my topic for today is trademarks. I will not go very deep into the evolution of the trademark, as we must have all heard the ancient trademarks, how the trademark has evolved over thousands of years. For example, the cave paintings in France earlier, around 15,000 years ago, had marks on them, which they used on their livestock to claim their ownerships. Also in Egypt, they around some 6,000 years ago, they would use some stone cutter signatures and stones to identify the source of the stone and the laborer who carried the work to claim their wages. Without going into the history of the trademark, I would begin with how the present business should be evolved and how trademark is important in when you start off a new business or you incorporate a new entity and go forward with the expanding the scale of business. So, for example, you have just started your entity. You have worked very hard on your business idea, your administration, your execution work, everything is in place. And then you imagine a world where your voice is borrowed by somebody else. Maybe your face is mimicked. All your hard work, your identity is claimed by somebody else in the market. So in such a bustling global marketplace, it is very important that you protect your name, your identity, and your trademark along with your business ideas. So just a business idea is not enough to start off with any business or entity. So let's go forward. Starting with what is a trademark? Now, the trademark is basically governed by the Trademarks Act 1999. It is a mark which is capable of identifying or distinguishing your goods or services of one entity in the market from the others. Trademark can be in many different forms. It can be a word mark, a device mark, a sound or a color or a combination of all. It can also be a trade dress. I will give examples for all of them so that it is easy to understand. And there are various marks which are just only words, and there are various marks which are a combination of both word and logo. And beyond the words and logos, the trademark are just not the names. They protect the sounds, the distinctive sounds, the color combinations, the shape of the packaging, the presentation of the mark, how they look, and many other things that is related to the brand. So the overall appearance and the image of a product is what distinguishes that particular product in the marketplace from the other related goods. So the main elements that would go into making a trademark would be its color schemes, the designs, the packaging, or even the layout or the design of the store in which the particular trademark or the brand has been sold or set for selling. Then the trade dress, which we're talking about here, it extends beyond logos and brand names to cover a product or service's overall visual appearance. It signifies the look and the feel of the product or the service. Like trademarks, the trade dress protection aims to prevent the consumer confusion and protect the goodwill associated with that particular product or service. It also protects the particular brand because we can register the entire packaging of the product or the shape of the product and the entire appearance as a whole. Now, there are various insights or a few important points that we need to know about trademark before we move forward. We must have all come across the symbol R on any brand name, which can be legally used only after a successful registration. And using it without registration can lead to significant legal risks. So once you register a trademark, you have it for your entire lifetime, subject to renewals. I will be covering the timeline for the renewals and such topics later in the presentation. Then a trademark once registered is equivalent to an asset, just like an entity holds a tangible asset like a property, a plant, or machinery, or any fixed asset that you can think of. It is equivalent to that, and the trademark is a very valuable, intangible asset that any entity can hold. You can trade that particular asset to another entity or individual for you can rent it out for a particular royalty amount. You can even transfer the ownership in that matter. Then the next part would be criminal consequences if somebody would copy your trademark or uh, pass off the usage of your trademark. So these are all the things which we will deal with over here in the topic today. Am I able to move forward? Okay. Now, a few examples of word marks would be words like Google or Nike. Then people also register for their personal names. For example, we have SRK. SRK is World or Khiladi, as you can see. Then people also trademark their signatures. One of the famous signature trademark would be the Sachin Tendulkar's signature. Then, as I said, we have combination of device mark with the words, and McDonald's is one of such example where the symbol M is appearing with the tagline below it. I'm loving it. Then we have color marks, that is just the design or the logo of it. And then the trade dress, again, I said it is the kind of the packaging, the shape of the product in which the it is packaged. For example, here we can see the label Coca-Cola is an example of the trademark, whereas the shape of the bottle in which the product is put, that is the trade dress of that particular brand. Similarly, you have seen Adidas. The Adidas logo and the words written below that is the trademark, whereas the appearance of the same on the shoe is the example of the trade dress. So by this, I think it is quite clear how the trademarks can be classified into words, logos, combinations, trade dresses, and device marks. Why should one register a trademark? So registering a trademark is not just a legal formality, but it is about owning your identity in the market. Imagine yourself building a business for as long as 5 years or 10 years, your name becomes extremely popular, and then suddenly somebody else comes forward and registers that particular name. So that legally stops you from using that particular name. So, what would you do in such a situation? Would you fight or regret not registering it earlier? So, before going in that situation, it is better that you oversee the entire business situation, the entire business scale scenario, and register your unique name before anybody else does. So, why do you need to register a trademark? The benefits would be exclusive right to use the mark nationwide. Once you register a trademark, you have the legal right over your mark. And without registration, if you use a name, you are just using that name. But after the registration, you just don't use it, but you own it. So it is very important that you apply for the name before anybody else copies it or before anybody else applies for it. So the second thing would be legal presumption of ownership. As I said, it gives a legal basis for to use that particular brand, and nobody can sue you in future for not getting it registered, or somebody else, if they get it registered, then you will not be in a legal position to even file a suit against that person. So yeah, then you can stop copycats. Like anybody can copy a brand that is not protected. So once your brand is protected legally, it will stop people from copying it. And even if they copy it, you will have a legal procedure that you can follow to stop them from doing that. For example, a local clothing brand becomes very popular. People do business over social media handles nowadays. So you see that within a particular span of time, there are three more people who are using the same brand name for the same products. So without a registered trademark, you will not be able to file an official complaint. But with a registered trademark, you can legally shut them down. So the next thing is asset that can be licensed or sold. We all know, I just mentioned earlier that it is an intangible asset which can be licensed, which can be given, which can be rented out to other entities or individuals for the use. And you can charge royalties to them for the usage for that particular span of time. Or you can also assign or transfer the entire trademark to another party if you don't wish to use it any further. So the benefits of registrations are covers these many things. We can also have some more things added to this. Now the symbol R that we use, it builds the trust instantly. Like we see a trademark in the market, any brand name in the market, and when we have the symbol R on it, it instantly develops trust for the people for that particular product, because we know that that brand is registered and there would not be any cheating that can be done from that party. It also protects your future growth. Today, you may be local in your business, but owning a trademark at an initial stage can help you go national, global, and even international. And without registration, the expansion becomes a little risky. So if you don't register it now, then later on when you are thinking of expansion, then you will have to make more efforts and additional documentations in registering your trademark. So it is better that you do it in the inception stage itself. The risks without registration, it includes limited protection. For example, you have started some business on local scale. In that scenario, only in that particular region people know you. So you will be able to work in that little scale for the entire time. And so in case you have to expand globally, it is very important that you get your mark registered so that a geographical restriction cannot stop you from growing further. then you cannot use a symbol R legally unless and until you have registered your trademark. Then in future, it is very difficult to prove your ownership in disputes where other people come in the market who copy your mark or go ahead with your trade names and they register before you. So it is better that you register it so that in case of any dispute, you have a legal basis, a legal charter on the basis of which you can fight the same. Then no custom recordation possible. In case of import of goods, only if your trademark is registered, a custom recordation can be possible. Otherwise, the same will not be possible. Like in the to the customs department, you can list out your mark so that if any international brand is copying your trademark and exporting it to India, then the same thing can be cancelled by the customs in India so that your rights are secured. Also, weak positioning in licensing negotiations. In this point, only if you own a mark or you have a trademark for a particular brand, you will be able to license it to other people for their use. Moving further, tips for a registrable trademark. I will get to the procedure of the registration of a trademark, but before that, we need to know that how to apply for a trademark that will have better chances of getting registered. Just blindly making application for any XYZ word will not get you to register your trademark. So it is very important that you see what you are applying before going further. So the first thing that you need to do is you have to choose a very unique invented name. So do not use what you cannot prevent others from using. Like if anybody else is already very popularly using some mark, it is advised that you do not try to closely imitate or copy or use similar words that represents or that might confuse people with that mark from yours. So it is advised that you use a unique invented name, and the best trademarks are the made up words. Like, for example, we have Google, Kodak, Xerox. Why are these the best examples? Because there is no already existing dictionary meaning of those words. They do not indicate anything, and they do not indicate their goods, what kind of goods they are using, or what kind of services they are providing. So a word which does not have any existing meaning, these are the best ones to go for your word mark registrations. It is also very easy to protect yourself legally from that. Second tip would be imaginative. Like you can coin a word and a logo together to make it an artistic device mark so that there is nothing like that in the market already. Create something out of the box. Avoid using descriptive words. Or, for example, if you are having a brand for the shoes, then avoid using the word like best quality shoes. Or if you are selling milk, then avoid using things like fresh milk or the best milk. These are the products, these are the titles that directly defines the product which you are dealing in. It is not the brand. They are describing the goods that you're dealing in. So there should not be in any direct meaning associated with the goods in the name of your brand. So, for example, a good example for that would be again Nike, as I said, because after hearing the word Nike, you will not be able to say what it is associated with. Now that they have such a huge usage for the shoe market, in the shoe market, so you know that Nike is associated with shoes because of its wide usage and popularity. Then the next would be do your research. You have to be very good at the research before applying for a trademark. You need to know if that there is already a mark which is registered, which is very similar or closely similar or visually or phonetically or the colors are similar to your proposed mark. So it is very important that you do your research very well before going for the registration of any mark. Next would be, and while doing your research, you should not basically rely on guesswork कि ये mark तो नहीं होगा registered, so कर लेते हैं. So it is better that you check every possible similarity, may it be phonetic similarity or spelling variations. Even small similarities can lead to objections and oppositions in the future for your trademark registrations. So before you go forward with your mark registration, it is very important that you think on a long term basis and not just for the current scenario कि अब कर लेते हैं बाद में जो होगा वो देखा जाएगा. Like it is best that you use such a word that can be used in a long term basis and on a large scale as well. So like you can ask yourself, if you select a particular word ABC, you can ask yourself, will this word even work after 5 years, or will I be using this consecutively for so many years or not? So it is also best to avoid using the location based names if you plan to expand. Avoid product specific names if you plan to diversify. So it is not important that the particular brand ABC is only related to the shoe industry or the clothing industry. I can also open up or initiate a different kind of service in that particular brand name. So in case you want to diversify your brand in many different fields, it is best that you avoid the product specific names or the location based names. Then along with the trademark, it is also important to see that you see the domain name and the social media handles along with your trademark proposed, because in today's world everything is digitalized, and there are businesses all over, not just in physical shops but on social media platforms and domains as well. So for that particular word that you have selected, you need to have a search with respect to the domain and the social media as well. You have to check the availability on the website, domains, the social media handles, the brand consistency, whether your identity is stronger or it is already used by lakhs of people. The next point would be making choice of the right class. Now, before making a trademark application, it is very important to see where you fall, where the product for which the brand is to be registered, in which class that particular product is falling. So, making the application in a wrong class can again make you lose your legal base, because you have made an application, but the class is not proper. So, you will not be able to protect your mark in that case. We have around 45 trademark classes, out of which from class 1 to 34, I will not list out all the classes over here, but we have, out of these classes, class 1 to class 34 belongs to goods. And from class 35 to class 45, these are related to the services. So it is very important that we classify what our product is falling into and then select the classes accordingly. You can also make a multi-class trademark application. It is not a compulsion to just make your application in one class. We can have more than one classes for your trademark application. If you miss the proper class, your protection will be weak. The next part would be, it is very important that once you have applied for the mark, it is very important that you use that particular mark consistently in the same manner in which you have applied it, like the same spelling that you have applied it, the same color combination or the logo or the format. Inconsistency in usage of your mark can also weaken your claim in any future possible disputes. Avoid names which are similar to already existing famous brands. So, in case you don't want future litigations happening, it is best that you avoid using the names of the brands that are already very famous and they are already being used very widely and on a large scale. Even a minor indirect similarity can be risky. So if you are using something close to a well-known brand name, that can lead to objection, then subsequently opposition. And even if you have registered the mark, it can later lead to further litigations by legal notice and things such like that. The next thing would be prefer distinctive and suggestive names. Now, the best trademarks are the ones which are unique, easy to remember, not directly descriptive. For example, if you go to see Netflix, net suggests internet, and but the entire thing does not tell you what Netflix can be. So it is internet plus movies, but it is an indirect association with the internet, but it is not directly suggesting anything. So it is a artistically formed word which nobody is already using, and you have a unique hold over the same. The easier your brand is to explain, the harder it is to register. So, like, just be very careful that your brand is not already describing the kind of goods or services that you are providing. A strong brand name does not just attract the customers, it will also help you in surviving the legal challenges that you may come through in the lifetime of your business. Now, moving forward, when you go to the to filing the trademark applications, TMA is the form that we use. Apart from TMA, which is used particularly for the application for registration of a trademark, there are various other forms, out of which I have listed a few important forms. One of them is TMM. TMM may be used for making any application for modifications or a request for any miscellaneous function in respect of a trademark application that has already been made. Maybe you can, if you want to obtain a certified copy of the entry in the register of the trademark, then you can apply through that. Or if you have done any error while making a trademark application, you can rectify or you can apply for the correction of that particular clerical error and amend the same through the form TMM. You can also apply for a duplicate registration certificate in case you have a very old trademark which you are holding and you do not have the details of the same. Then you can apply for the TMM for extension in TMM for extension of time for making submissions with the trademark authority. Then various such other requests can be made through the form TMM. The next important form is TMO. TMO is a form which one uses to file oppositions or rectifications or uh, all the submissions with respect to the oppositions and rectifications are filed through this form. Then the next important form is TMR, which is the form which is filed for trademark renewal. So a trademark once registered is valid for 10 years, and you have to renew your trademark every 10 years, and which is done through the form TMR. Next is TMP, which is filed for alterations or assignments. Like, for example, a person is transferring its rights over a particular mark to some other person, one applicant to another person. So you can do that by filing TMP. Now, other key aspects that we need to keep in mind are, one is the validity period. Trademark once registered is valid for a period of 10 years. Then the government fees for filing a trademark application is 4,500 for an individual and 9,000 for a body corporate or a partnership firm or any entity. If the entity is a small enterprise or is holding or it is a startup registered enterprise, then the government has provided concession for that particular entity. So they will not have to pay a fees of 9,000, but only 4,500. However, for renewal, whether you are an individual or an entity, you will have to renew with a fees of 9,000 every 10 years. So, in how much time the trademark gets registered? Whenever a client comes to us, the first question would be, "कितने time में trademark मिलेगा?" So, this is a very critical thing, because once we make the application, it is completely upon the department how much time they take to examine the mark or raise any objections, if any, and proceed further with the entire process. I will be dealing with the entire process one by one. And mostly, if there is no unnecessary delay from the end of department, it should take around 12 months or maximum 2 years for a trademark to get registered if there is no objection or opposition. So in case there is a objection or opposition, then the time will expand to 3 years, 5 years, or even more, depending upon the complexity of the case. Renewal, I've already talked about. Once your trademark period has expired, the 10-year validity period, once it has expired, and you have not renewed it within the period of 10 years, you will get only a 1 year grace period for restoration of your trademark. So, in all, there is 11 years that you have for the renewal and restoration combined. So, after that, you will not be able to pursue the same, and you will have to make a fresh application with fresh documents. And it is difficult to maintain a document database for the 10 years, for the past 10 years, or for how many years that you have been using your mark. So it is very important that you put a reminder for your trademark renewal once you have registered it, because it is just because of that one clerical mistake, your mark is out of your hand and somebody else can register it in your place, and the entire goodwill that you have created over so many years, it all gets lost in a second. So the key aspects are covered. Next would be overview of registration process. So we have talked about the trademark search. The first step towards a trademark registration would be taking a trademark search. Ensure that there is no conflicting mark that is already existing. There is, whether I've already talked how in what manners the trademarks already existing can be similar to your proposed mark. So after a thorough search, you can make the application either online or offline with necessary documents and government fees. So once your application has been filed, the trademark department will examine the same. Usually the time taken by the department to examine should be 3 to 4 months. But currently, if you go to see, the marks that we have applied in 2024 are being examined now. So it is the because of reasons best known to them, there has been a tremendous delay in just the examination of the mark. So that has, in the current scenario, expanded the trademark registration timeline to unknown number of years. Then the next step would be publication in the trademark journal. Once the trademark department examines your application, if it is acceptable to that particular if it is acceptable to the department, they publish the same in the trademark journal. And if not, then they will raise an objection in the examination report. So if there is no objection in the examination report, the same will be registered in the trademark, published in the trademark journal, and it will remain published for a 4 month window. So the 4 month window is for the public to raise oppositions, if any. So if there is any person whose rights are getting affected because of your proposed trademark, that particular person can file an opposition against your trademark, and which will lead to further opposition proceedings. So once the objections and oppositions are cleared, then after the 4 month is completed, in case of no opposition, and after the hearing is completed, in case of opposition, you will finally, either the trademark will get rejected or you will get the approval and the certificate. So this is the a brief summary of the entire trademark procedure. we will break up the procedure and see the hidden processes that are lying in between. For example, after making a search, you have applied for the trademark, may it be word or a logo. So in case of word, it is very easy to determine the similarities because the search mechanism will be such that they will automatically see what similar spellings are existing. But when it comes to logo, it is very difficult to examine what kind of logos are already existing. So performing a search for the logo is quite difficult as compared to the word mark. So have you ever wondered how the trademark office compares lakhs of logos so quickly? Because yours is just one in a million application that is already existing in the trademark registry. So it is not magic. It is called Vienna codification. What is Vienna codification? It is the process that happens between the application and examination by the department. So once the application for a device mark is received by the department, it is sent for Vienna codification process. So in this process is an international system which is used to classify the visual elements of logos, and it is governed by the World Intellectual Property Organization. It helps the trademark registry to identify the similar logos, conduct image-based searches, and avoid confusion between the marks. So it is a system that converts your logo into a searchable legal data and then present to you for simple understanding. Just like the trademarks have classes for goods and services, the logos have classified their own classified codes for their design elements. How does this code works? Now, each logo is broken into visual components, and each visual component is assigned a Vienna code. I will explain the same with example. The classification categories, the system divides all visual elements into 29 main categories with subcategories further. So the important ones may be, just for example, category 1 will be the celestial bodies, which may be sun, moon, stars. Then category 2 could be human beings, which identifies men, women, children. Category 3 will be animals. 4 will be supernatural or mythological, gods, angels, mythological figures, etc. Category 5 would be plants, trees, flowers, leaves. Category 6 would be landscapes, mountains, rivers, and sceneries. Category 7 would be buildings, houses, and monuments, and so on. So there are these visual elements which are divided into various categories. So a single logo can have multiple Vienna codes depending on the elements that are included in your logo. So for example, your logo is having an animal figure or a bird figure, and then it has a star in it, or maybe they have a human figure in it. Then it will all get classified into that particular category. And imagine your logo has a lion and a crown with it. So it will be classified under the animal category and the symbol category. So instead of searching visually, the system uses these codes to make the trademark search. So Vienna codification process in India is such that once the logo has been filed, the codification will be done by the registry, and basis on the basis of that, the trademark office will examine your logo. It will assign the relevant Vienna codes, and in at this particular stage, if you put your application number in the e-register, the status of your application shows as sent for Vienna codification. So we always wonder what that particular line means. So this means that they have sent it for the classification of your particular logo. Once the code is allocated and the logo elements are categorized, the codes are tagged in the system, and then the examination begins. And then later on, your application moves to the examination stage. Here you can see the third step, which is examination. So it usually takes 1 to 2 months, as I said, for the examination process to begin and complete. Then Vienna codification helps you to detect the similar logos. The similar visuals or names can be brought into notice to the department so that they can examine the trademark accordingly. It also strengthens the trademark search. The examiners use those codes to compare thousands and lakhs of marks. So they have to make sure that there is no confusion in the market or there is no visual similarity that exists in the market with your name, because many applicants ignore the logo similarity, but the codes consider visual impression very seriously. You apply for a logo with a lion symbol, and another company already has a lion logo in the same industry. Like, even if the names are different and the particular sign that you are using is same, then the Vienna classification will help to detect that particular similarity, and all the brands with the lion figure in it will come in your examination report as similar uh, alleged marks. So words can be different, but if your logo looks similar, your trademark can still be rejected. So here are a few tips while making a trademark application, keeping the Vienna codification in mind, that you have to make your logo very unique, so that a unique logo will always make it easier for your trademark to get registered. You may avoid commonly used icons and symbols, and do a device search. Search using Vienna codes or image search. We have the AI-based search nowadays on your trademark registry, where you can search for similarities in logos as well. Then combine the elements creatively to create an altogether new kind of device. Instead of generic symbols, create abstracts or unique designs so that there is no question of similarity in the market. You have to protect both your word as well as the logo. So a trademark search is for the logo is as important as a trademark search for the word. Now, if you are going for only a word mark, then Vienna codification will not apply. So the last point over here is what it does not apply to. It does not apply to the word mark applications. It is only designed to classify the images and not words. So plain word marks will straight the way go towards the examination by the trademark department, and not Vienna codification. So a simple way to explain that could be, if your trademark can be seen as a design, then the Vienna will apply. If it can only be read as a text, then it will not apply. Now here is a overview or a more familiar view for the trademark procedure that I just explained. You can see starting with filing of applications, cash receipts. Once you have filed your application, you will be allotted with your application number. Then there will be a data entry done if you are applying physically. The same would be scanned or sent to Vienna codification in case it is a device mark. Then the same will be examined, and after due examination, an examination report will be dispatched to the applicant. So there will be two possibilities after examination of any trademark application. One would be where the trademark application is accepted, and the other possibility where it contains objections. So if it is accepted, then it will be straight away published into the trademark journal, and where it will hold the same for 4 months. And if there is no opposition, the same will get registered. And after the registration, as I said, you will have to take care of the renewal and post registration changes, if any. So if there is an opposition, then you will have to proceed with the opposition proceedings. And in that opposition proceedings, if your trademark is accepted, then it will get registered, or else the application will get abandoned. So the other possibility of the examination report outcome was objected. The first one was accepted, which I have dealt with, and the second one is objected. So if your trademark is objected, then they will give you grounds of objections, like the reasons why it is objected. You will give your submissions for the same. I will deal with it in detail in the later slides. Then if the trademark department is not satisfied with your submissions, they will hold show cause hearings where you will verbally explain to them why your trademark is uh, entitled to get registration. So there it will be either refused, or you will either withdraw your application voluntarily, considering the inability to register the same. So then later it will get either registered, or you will withdraw it, or the same will get refused. So these are the possibilities in any trademark application process. I have dealt with the Vienna codification process. Now, I have been talking about opposition and objections throughout my registration process overview. So we will learn the major differences between objection and opposition. So a layman will not understand कि objection क्या होता है और opposition क्या होता है. They want to register their mark as soon as possible. So once you file an application, the department raises objection. So the objection is raised by the trademark registry or the examiner of your trademark, as you can say. Whereas the opposition is raised by the third party, and which happens at a later stage when the department has already accepted your mark for publication. And after that publication, there is a third party that is raising the objection. So this is an initial stage. Objection happens in an initial stage before publication in the trademark journal, whereas opposition happens after publication in the trademark journal. In objection, there are only two parties involved, and the two parties are the trademark department and the applicant. So the communication is happening between the applicant and the department. So whatever objection is raised, it is the applicant who is supposed to answer the same to the department only. Whereas in case of opposition, there are three parties involved: the applicant, the opponent, and the trademark department. So the communication is happening between the opponent and the applicant, because the opponent has filed the opposition. So the next submission will be a reply from the opponent to the opponent by the applicant, keeping in line the department as well, because the department has to be informed of every step that is taken over here. Now, the grounds of objections are absolute and relative grounds, whereas the grounds of oppositions will be mainly like, I am using a mark which is similar to what you have published, or I have prior rights over this mark and this person has applied it later on. So I am the actual owner of the mark. So people on such grounds, they usually go for the opposition process. Then objection is raised by the department usually in a period of 1, 2, 3, 4 months, and the applicant is supposed to reply to that examination report in which objection is raised within 1 month. So after that, the outcome would be either it is accepted, in which case it gets published, or the other outcome is it is refused. The timeline for oppositions we will see in the later slide in detail, but briefly, it is the 4 month period in which it is published in the trademark journal. Any person can file an opposition, and thereafter, to make the submissions against the opposition, the applicant gets a 2 month period time, and then further evidences are reduced by both the parties within a period of 2 months each, respectively. So in that case also, when the case moves further, the outcome will be either the opposition is allowed. If the opposition is allowed, then the trademark application gets refused. And if the opposition is not allowed, then the trademark application will get sustained, and the opposition will get abandoned. Now, I would like to deal with the grounds of the objection a little deliberately. So, the legal grounds of objections are that are raised by the departments are absolute grounds under Section 9 of the Trademarks Act. Now, these relate to the nature of your trademark itself. Like, as I have said earlier, that you have to select a mark which is not describing your product or services. So, the common reasons are descriptive marks. So, under Section 9, you will get a query or objection in your examination report because you are using generic terms for your trademark. There is a lack of distinctiveness. Like, for example, trying to register a sweet dish, register the word sweet for your mithai business. So it is not describing the brand, it is describing the product directly. So in such a case, this is called the absolute ground for raising objection. And under this ground, your trademark will be liable to get refused right away. Now, the second ground could be relative ground, which is under Section 11 of the Trademarks Act. These relate to the conflict with existing trademarks. And the common reasons would be you are using a very similar spelling to an already existing word which is registered. Or if your word is the spelling is different, but the sound of it is same, it is phonetically similar. Or in case if it is a logo, then the color combination is so same that it is very difficult to identify or differentiate your mark from the alleged similar mark. So even a slight variation can cause confusion. So according to the department, based on the search that they perform, whatever marks are similar to the mark that you have applied for, they will cite the same in the examination report and give it to you um, for your reply. So, in the examination report, what are the contents of the examination report that you receive? So, the first thing would be, of course, the grounds of the objections. Like, if there is no objection, that straight away it will be written that your mark has been accepted. So, in that case, the content will be very simple. But if there is an objection, then the examination report will include the objection reasons why it is objected, like the relevant section 9 for the absolute grounds and 11 for the relative grounds. And if it is an objection under section 11, they will cite all the conflicting marks. Then they will also mention the time limit to respond to the examination report. You must reply within 1 month. If you have not replied within 1 month, then irrespective of all the explanations and submissions that you might have submitted, your application will get abandoned and you will have to make a fresh application altogether. Now, once you receive an objection, how do you respond to an objection? It is the most critical part. Your reply must include the legal arguments. Explain why your mark is distinctive and does not cause any confusion. If there are cited marks, then you can pick up those marks and state out uh, various various statuses as to in what manners your mark is different from the cited mark. So you can list out your mark and the cited marks hand in hand and point out all the differences. You can also put out some case laws which can support your arguments, and judgments will always strengthen your replies. You can also give away proofs of usage in case you are using your mark since a very long time. So this is also a very important that you have to see before making an application of the trademark. Uh, People can apply in two different scenarios. One is where you have not yet used the mark. It is a newly established. It is a new brand that is yet to be established. So you put it in the proposed to be used category. But if you are already using the mark, then you have to provide a user date from which you are using the mark, for which the application will be supported by necessary affidavits and supporting documents, and you can claim your usage. If I'm using a particular word ABC since 1987, and I have my bills and invoices in that particular name. It that my bills have that trade name which I have applied for. So I can present those bills and I can claim my usage since 1985 or 86 or whatever date since when I'm using my mark. So there are these two different scenarios. One is you have a prior usage, and the other one is where you will use it in the future, which is proposed to be used. So, in case you get an objection, you can further put proofs of usage, which is invoices or advertisements that you might have made, or any social media presence that your mark might have. It shows your goodwill and reputation and prior use of the mark, which makes the weight of your objection reply better. It gives weightage to your reply and making the chances of it getting accepted better. Now, next, once you have submitted the reply within time, the department will peruse the same, and if it is satisfactory, it will accept the mark and publish it in the trademark journal. If not, then an opportunity will be given to you wide show cause hearing. A hearing will be scheduled and the notice of the same will be provided to you on your registered email ID, phone number, whatever you have provided at the time of the registration application. So the most possible outcomes will be that if you have drafted a strong reply to the objection, the most probable outcome would be that your examiner is satisfied and it has moved your application to the journal publication. And if it is refused, then the application will get rejected and it will get abandoned if the reply is not filed in time. So more than 60 to 70% applications receive objection, and it is very important that you reply it in time. And a large number of applications get approved on the basis of a properly drafted reply. So it is very important that you don't miss any deadlines when you are working on a statutory platform. Opposition. Here I have dealt with the objection in details. So I've dealt with what is a trademark objection, when does it occur, what are the grounds of objections, the examination report contents, how you are supposed to respond to the objection, and the hearing stage, and then finally after the hearing, if it is accepted or rejected. Similarly, we will deal with the opposition process in detail. Now, once your trademark is accepted, the job is not done. Your trademark might be accepted and approved by the government, but that does not mean it is safe because it is not registered yet. The public is getting a chance to challenge it in that 4 month span of time. So, what is a trademark opposition? As I already said, a trademark opposition is when a third party objects to your trademark after it is published in the trademark journal. It is basically saying that your trademark should not be registered because it is affecting my right. It is a third party saying to you that it is affecting my right, and they are raising opposition in respect of the same. It is raised by common people, public competitors, or prior users, and it is a legal proceeding in itself. So, what when does opposition occur? It is happening after the mark is accepted and published in the trademark journal. So, opposition, as I said, can be filed within 4 months. And if there is no opposition, then the trademark will proceed to registration and the applicant will receive the registration certificate. Who can file opposition? The people filing opposition can be existing trademark owners or prior users, even without registrations. The word that you have applied for, it is possible that you have applied for a word that somebody else is already using. So, such a process is protecting that particular person's right who is using that particular mark even prior to you. So any person who is likely to be affected, not limited to just registered owners, they all can file oppositions. Now, what are the grounds for filing the oppositions? The 90% grounds would be similarity or likelihood of confusion. That is the most common ground. And the other, as I said, is the prior use. Like even if it is not registered, the earlier user has a right towards filing an opposition towards your mark. So like maybe that his mark is first in the market and you have applied it later. And if he has noticed it that it has been published in the trademark journal, then he has every right to oppose the same. Next, bad faith. The applicant, that means the applicant has copied the mark intentionally, so it is protecting the right of the opponent. Opposition procedure. The opposition procedure is governed by the Trademark Rules 2017, read with the Trademarks Act 1999. Now, the first step towards opposition would be filing an opposition by the opponent in the form TMO. It will contain all the grounds and arguments of the opponent as required under Rule 43 of the trademark rules. Then, once the opposition is received, the trademark department will send an opposition notice to the applicant कि तुमको applicant को opposition आया है. So you have to, the trademark department in that notice will direct the applicant to file a counter statement under Rule 45 within 2 months. So if that timeline is not complied with, then the applicant's trademark, the application will get abandoned. So after this stage, when the trademark applicant has filed the counter statement, the both the parties will get a chance to produce the documentary evidences and proofs of the usages and all the supporting documents. So after the counter statement, within 2 months of receipt of the counter statement, the opponent is supposed to file evidence in support of his opposition in within 2 months under Rule 45 of trademark rules. And within 2 months thereof, the applicant is supposed to produce the evidences in support of the application under Rule 46. Either if you don't want to submit any evidences, then a letter to that effect has to be at least submitted that at this stage that particular applicant or opponent does not have any further submissions to make, and they will be producing it later at the hearing stage or whatever. Submission has to be made within 2 months. If there is no submission, then under the respective rule, the application or the opposition, as the case may be, is liable to get abandoned. Then after all the submission process is completed, then the hearing takes place. And after hearing both the sides, the registrar, after hearing both the parties, will take the decision, and either the application will sustain or the opposition. So accordingly, the entire process takes place. Moving further towards trademark journal. Now, I have been mentioning all the time that the trademark, once accepted by the trademark department, the application, once accepted by the trademark department, is published in the trademark journal. Now, what is a trademark journal? It is a booklet or a journal, as you say, where the public gets a chance to challenge it. The public, how will the public come to know that the particular trademark is accepted by the department? It is through the journal that they publish is how the public will get to know about it. What is a trademark journal? It is an official weekly publication issued by the Office of the Controller General of Patents, Designs and Trademarks. It contains all the accepted trademark applications in that particular week and the marks which are open for public opposition. Think of it like a public notice board for the trademarks. So it is the word that this brand is about to be registered, and you have to. This is the time where you have to speak or file an opposition, or later on you will not get the chance to do that. So when does the trademark enter the journal? As I have already mentioned, after filing the application, the examination is done. If it is accepted or if there is an objection and the objection gets cleared, the trademark gets accepted and then it is published in the trademark journal. So what are the informations that are included in that particular journal? So your trademark entry will include your applied mark, which could be your word or logo, the applicant name, the class in which you have applied the mark, the description of your goods and services, and the application number, and the date of filing, and the date of the trademark journal, of course, because the 4 months period will be calculated from that particular date. So after that, there will be an opposition window, which I've already mentioned. That is the 4 month window which will get opened. And during this time, any party can file opposition, and there won't be any extension beyond the 4 months period. Now, why the trademark journal is important? Because it protects the existing brand owners. The competitors can monitor, stop conflicting marks, prevent market confusion, and ensure that there is no brand similarity coexisting in the market. It creates transparency, and the trademark system becomes an open and fair market to play. What happens after publication? That we have already dealt with, that is opposition or no opposition. So we have dealt with that particular process. Now, how to access the journal? It is available on the IP India website. You can search by class or any keyword or the trademark. So that is how you can access the journal. Next would be defending your brand. Now you have done your application is registered. What next? The next part would be defending your brand. So it is very necessary that you monitor and watch, keep a watch. Once your trademark is filed, you must continuously monitor through trademark journals कि किसने नए applications किए हैं, marketplaces जो है online वहां पे कोई आपका trademark copy कर रहा है. You can issue a cease and desist notice. And even if that is not helping, you can file an infringement suit and initiate a criminal action against the infringer. Then customs recordation, in that you can record your trademark with customs to prevent the import of counterfeit goods bearing your mark. Then next comes domain name disputes. In the domain name disputes, we use the UDRP INDRP proceedings to recover domain names registered in bad faith using your brand. So a domain, earlier there were no domains, but in today's world, domain is growing. The domain portion is growing very in a speed that cannot be matched. So UDRP and INDRP, I will quickly summarize what it is. For example, you build a brand for years and somebody else registers a domain in that particular name and asks you to pay a particular amount, and then only you will get it back. That particular activity is called cyber squatting, and that is where UDRP and INDRP comes into picture. So UDRP is governed by Internet Corporation for Assigned Names and Numbers, and it is applicable to global domain names like .com, .net, or .org. And to file these two applications, you must have three conditions fulfilled, wherein your domain name is identical to the particular domain name is identical to your trademark, the registrant has no legitimate rights, and the domain is registered in bad faith. So the process is simple. You file the complaint online, the panel is appointed, and the decision is done in 45 to 60 days. While in INDRP, it is more like an arbitration process, and it will take it is a slightly longer process, and it is for the .in domains. So the major difference between both of them is the .com, .org, and the .in domains. So that is it about the domain name disputes. We have to take care about the critical timelines that I have mentioned throughout the presentation. That is replying to the examination report, then the opposition window, then making the opposition submissions. So if the timelines are not taken care of, then the application is entitled to get abandoned. And the registration is valid for 10 years again, and it is renewable indefinitely every 10 years. Now, I have only dealt with one component of the intellectual property right, that is the trademark, whereas there are many others which I will quickly summarize, one of which includes copyright, example of which is a book or a song or a movie or any artistic work. The validity is 60 years and it is governed by the Copyright Act 1957. Second would be patent. The example would be medicines or machineries. The validity period is 20 years and it is governed by the Patents Act 1970. Next would be industrial design, like a shape or configuration or a pattern. For example, the shape of the packaging bottle or the jewelry design, etc. The validity period again is 10 years and it is governed by the Designs Act 2000. Next is the geographical indication. Again, the validity period is 10 years and it is governed by the Geographical Indications of Goods Registration and Protection Act 1999. Next would be the integrated circuit layout. It is a 3D multi-layered blueprint defining the precise geometric arrangement of transistors and interconnecting wires on a semiconductor chip. These are the original layout designs which people create and they can register the same. And the validity again is 10 years and it is governed by the Semiconductor Integrated Circuits Layout Design Act 2000. The last one is trade secret, and there is no specific law to protect your trade secrets. And you can execute non-disclosure agreements or confidentiality contracts to protect the rights in under trade secrets. Trade secrets examples would be a certain formula or a process or your vendor client list. For example, the Coca-Cola formula or the KFC's 11 herbs and spices or the Google search algorithm. So in order to protect your trade secret, it is important that you have proper legal documentation. I am done with my trademark session. So Ravi, over to you
Thank
for
you.
any question answers.
Yes, yes. Forum is open for question and answers. Feel free to ask. I think no questions. Thank you so much, Bhagirathi, for the insightful session, and thanks to the wonderful audience for the questions and active participations. Thank you.